All right, good afternoon and welcome to the first episode of Pipelines 101. I'm Shelley Robbins. I'm Energy and State Policy Director for Upstate Forever, an environmental advocacy nonprofit that serves the 10-county upstate region of South Carolina. And with me today is Michael Corley, attorney and upstate coordinator for the South Carolina Environmental Law Project, or SCELP. SCELP is a nonprofit public interest law firm dedicated to the protection of South Carolina's environment. Now, that's me. You don't need to see much of me. So why are we offering this webinar series? Well, in 2016, Dominion Resources proposed a 55-mile natural gas pipeline that would impact 4 upstate counties of South Carolina and more than 70 stream and river crossings, including some areas that Upstate Forever had identified as conservation focus areas. So we intervened in the certificate proceeding and were represented by SCELP and specifically by Michael Corley. We also benefited from the talents of David Sly, Conservation Director of Wild Virginia, and our own GIS manager, Katie Huddle, and those two will join me to share expertise on episodes 2 and 4. Now, ultimately, that pipeline was granted a certificate of public convenience and necessity by FERC, the Federal Energy Regulatory Commission, and it was built and it's now in service, but it caused significant problems along the way. We recognize that given the current market and regulatory structure, there will be many additional natural gas pipelines proposed in the Southeast, and we want to share what we've learned. So we started our intervention process with no background in interstate natural gas pipeline regulation, and the learning curve was very steep. We learned as we went along, and once the process was finished, we realized that other communities could benefit from a crash course on this issue. So in this 4-part webinar series, we'll try to share with you much of what we learned. We'll also plan to record each webinar and make the recordings as well as the PDF slide deck available on our website, and we'll also try to make it easily searchable on the internet as well. This series was made possible by funding from a private donor, and we are extremely grateful for that. This episode will be an overview of the relevant statutes, such as the Natural Gas Act, NEPA, and others, and Michael will also go through the FERC certificate process. And then at the end, I will demonstrate how to find what you're looking for on the FERC website, which is not the most intuitive or user-friendly website ever created, and I'm sure that is no surprise. And in the second episode this coming Wednesday, David Sly of Wild Virginia will go into detail on the one piece of the process that does give states some authority, and that is the 401 certification of the Army Corps of Engineers nationwide 12 permit for water impacts. David will explain what's involved in the 401 certification and where the insertion points are, and then he'll share some of the latest developments in this arena, and that is changing pretty much daily with new court rulings involving both the Atlantic Coast Pipeline and the Mountain Valley Pipeline. In the third episode, a week from today, I'll explain pipeline construction. I'll also explain decatherms and how you can use them to fully understand how big a pipeline is beyond just its diameter, what size demand it's meant to serve, and whether that demand is realistic or perhaps artificially manipulated in order to justify the pipeline to FERC. And I'll also talk about natural gas exports and prices. Exports are increasingly driving pipeline construction, and experts believe that exports will drive domestic gas prices up in the long run. And then in the final episode on October 31st, we will talk about the impact pipelines have on conservation easements and on timber properties, and these can be significant. I'll share some right-of-way contract best practices that our upstate timber owners were able to negotiate, and we'll share the GIS process that we used in order to identify all the property owners along our 55-mile pipeline. We used that information to communicate with them regarding their rights, as well as to make sure they were aware of some meetings and input opportunities. David Sly will share some of the various monitoring tools and programs that other communities can learn from and use. So let's get started on this one. We'll leave time at the end for questions questions, and you can submit questions using the question box on the control panel on the right side of your screen. And then and you can submit questions for either me or Michael. So we're going to be talking about a very specific class of pipeline, interstate natural gas pipelines that are regulated by FERC. Liquids pipelines such as Kinder Morgan's Plantation Pipeline or the Colonial Pipeline that carry liquid petroleum products such as gasoline, diesel, jet fuel, those fall under separate regulation, and states generally have a little bit more say in those projects. And some natural gas pipelines are strictly intrastate. That is, they never cross a state border. And those two are under more state control, and we won't be talking about them. Finally, there are natural gas distribution lines, those controlled by your local natural gas authority. They carry the gas from the big transmission lines at a juncture, which is called a city gate, to the individual consumers, large and small, and we aren't talking about those either. We are talking about these. So you can go to the INGAA website, that's the Interstate Natural Gas Association of America, and you can play with this map. You can turn systems on and off, look at where the individual systems are. You can see on the right side that you can toggle individual systems on and off. Note that the Atlantic Coast Pipeline and the Mountain Valley Pipeline are not on this map. They haven't been completed yet, but once they are, and assuming they are, they too will show up on this map because they will both cross state borders. Now, hone your eyes in on South Carolina, and I'll use this system as an example to show you what I mean by interstate. Oh, there we go. All right, the blue lines represent Dominion Resources transmission system in South Carolina. Now they all tap off of Williams Transcontinental's major East Coast pipeline that crosses the state. I'll show you that one separately. That's the Williams, which I isolated that on that other map. So the Williams Transcontinental is the major East Coast pipeline that crosses the upstate. Many call that one Transco for short. Transco carries natural gas up from the Gulf of Mexico. And so this is currently not fracked gas. That might change. See, I'll show you that again. That might change because they have a project underway called the Atlantic Sunrise Project. But right now it is coming up from the Gulf of Mexico. And so Transco is a FERC-regulated interstate pipeline system, but so is Dominion's system called the Dominion Carolinas Gas Transmission System. Now, why is DCGTS interstate? Well, you have to look down at the bottom. If you can see that C-shaped piece, that piece actually extends into Georgia to the LNG or liquefied natural gas port at Elba Island. And at one time, the plan was to import natural gas into the South Carolina system and into the southeastern United States, but that never really took off. And the port is now being converted into an export terminal that will come online by the end of the year. And tune into episode 3 if you want to hear more about that. But that extension of the pipeline into Georgia makes the system interstate, and therefore the whole thing is regulated by FERC, not by South Carolina. That dotted green line is our 55-mile project now in service and the reason we're here today. And if the Atlantic Coast Pipeline is extended into South Carolina, or if there are any additional changes made to the DCGT system, the FERC process will kick in. let's see. Also, any changes like the Southgate project or the Mountain Valley Pipeline, that also triggers FERC. Any changes to Transco, Atlantic Sunrise, the Southern Trail project they just filed this summer, all of those lead to the FERC process kicking in. Now, speaking of the FERC process, that leads us to Michael Corley, and I will turn it over to Michael to go over the process.
Hello, everyone. Good afternoon. Thanks for being here, whether you're listening now or sometime in the future. I'm excited to be creating this little pipeline time capsule, so to speak. But I'll start by just talking a little bit about FERC, following up on what Shelley's covered. Federal Energy Regulatory Commission, they regulate interstate transmission of gas, oil, and electricity. And as Shelley was basically indicating, almost everything is interstate. Our pipeline framework is so interconnected that even when a link within that framework is being built entirely within South Carolina, like the system that Shelley and I were involved with, it's considered interstate because of its interconnections with the rest of our infrastructure. FERC also regulates hydroelectric dams, which is the only time I'd encountered this agency prior to my involvement with Shelley in this pipeline project. So if you're an environmental practitioner like me, and you're not working regularly in the energy field, chances are you haven't encountered FERC, which makes things very difficult because FERC does have special rules, special processes, procedures, even a special electronic filing system. And Shelley hit the nail right on the head. It's a steep learning curve that she and I both climbed together. There's 5 commissioners at the head of FERC, and it's a little bit of an unusual situation in that it's mandated by law that those commissioners be bipartisan. So out of the 5, at most 3 of any political party. So even in the day and time we live in, we have a situation where President Trump appointed a Democrat to serve on the FERC commission, which is quite unusual, of course. If you follow the news at all, you'll see the primary criticism of FERC is that they green light all pipeline projects. That's the way you see it portrayed in the news. And you could point to a few reasons why that might be the case, but one of those reasons is undoubtedly the Natural Gas Act, which I'd argue is written to facilitate approval of the pipelines. And just to cover a little bit of the history of the NGA, one of the first questions I asked myself when Shelley and I were taking this on is, well, what does the Natural Gas Act say about the environment? How does it account for environmental concerns? And if you look at the text of the statute, it doesn't really talk about environmental concerns at all. That's left to other federal environmental statutes. And part of the reason for that is it goes back to the history, which was based around market regulating. And that still very much drives FERC's application of the Natural Gas Act. The objective of the Natural Gas Act is a fair and flourishing natural gas market, right? And that comes primarily by approving pipeline projects. The focus of my presentation today is going to be for those of you out there who seek to influence the pipeline approval or consideration process. How do you accomplish that? And one of the first things I realized when I was starting out on this, seeking to accomplish that objective, is that the Natural Gas Act sucks a lot of air out of the room. And what I'm talking about with that is this preemption. It has casts a broad swath of preemption. With some qualifications to come, it's very difficult to find protection from natural gas pipelines within state law because state laws are preempted. South Carolina has actually a very progressive eminent domain law for oil pipelines and other type of pipelines, but you can't apply that. You can't seek protection there as it relates to natural gas because of preemption. Our state environmental laws don't apply to these pipelines because of preemption. Local zoning and planning, if you were to try to seek some refuge there, those are also preempted. So when you lose that state and local oversight, the process becomes more impersonal. It becomes more difficult, frankly, to influence the process. You're left with only these federal laws and primarily federal agencies. And, I think to sum things up, what Shelley and I encountered is this is one of the toughest type of projects toughest processes to get at from a standpoint of influencing decision making. It's difficult to find a foothold and find a way to make a difference to improve these projects based on the preemption of the Natural Gas Act. So moving on to the FERC process, Shelley, you can flip to the next slide. Here are the three main procedural steps for the permitting of natural gas pipelines. These are the primary phases or steps in the administrative process through FERC. And you see the first step there is pre-filing. I say there it's voluntary, which means it's optional, but it's become an industry standard as far as I've encountered. If you're gonna face a pipeline project, chances are they're gonna go through this pre-filing process. That process was created in 2002, and the overall purpose of creating that process was to make the certification, the permitting, the certification process for pipelines go more smoothly and more quickly. But as a byproduct of that, you also get the process. Pre-filing makes the process more open and interactive. As a result of pre-filing, you have earlier, more direct interaction between FERC, the pipeline company, other agencies, landowners. As a stakeholder, because of pre-filing, you have a chance to have more interaction and more voice earlier in the process than you had before pre-filing came into place. That makes it critical if you're, again, seeking to influence this process, critical that you engage as a stakeholder in the pre-filing process. Absolutely. Early engagement is key. I've encountered as an environmental lawyer, and I'm sure that you other environmental practitioners listening have, that very often by the time I see a project, a proposed project, so much time and resources have been put into formulating a plan for that project that the idea of going back and changing that plan is something that the plan proponent is very hesitant to take on. Just the cost and disruption involved in a late stage change in a plan, and it's very difficult to accomplish. But if you get involved if you raise an issue in pre-filing, before everyone becomes so entrenched into their positions, possibly the permit applicant and FERC can be more responsive to the concerns that you raise. You raise it later, and the cost may be prohibitive for those parties to show that level of responsiveness. I'll talk about the details of the.
I'll jump in here and just say that when I go over the FERC website, I will show how to monitor pre-filings, how you can just kind of periodically check and see what's been pre-filed.
Right, and then we'll discuss it. You can't be an intervener in the pre-filing process, and we'll discuss exactly what that means later in later slides. So after you go through pre-filing, you go for your application. This is, if you want to call it a quote unquote FERC permit for your natural gas pipeline. The Certificate of Public Convenience and Necessity is your FERC permit. That's your statutory approval under the Natural Gas Act. We're going to explore exactly what that certificate is, how you get it. But that certificate is your approval from FERC to build your pipeline. As we've already hinted at, there's some other approvals or denials that are going to come into play independently of the certificate. But this certificate is your final FERC approval for construction. Then the part that adversarial lawyers like me enjoy, the post-decision appeal processes as a standard for administrative law. There's opportunities provided to challenge a certification decision. If FERC approves a pipeline, you have the opportunity to challenge that approval. But once again, FERC, it's a unique and unusual administrative appeal, unique and unusual administrative appeal process and administrative appeal rules that are very important to know when you get into this situation. And you talk about influencing the decision. You've got to follow your proper steps to preserve your right to file that post-decision appeal, right? You've got to take the steps necessary to put you in a position where you're allowed to file that post-decision appeal, and we will see those steps as we proceed. Okay, Shelley. So here are the basic steps of the pre-filing process. And if you think about, the purpose of pre-filing, which is this sort of no surprises idea, the steps really make sense. initial notification, stakeholder notification is the first step. A lot of the times as an environmental lawyer, I worry that projects are going to be permitted before anybody ever finds out about it, and that a permit will be issued and the appeal period will have expired before anybody knows, sort of this under the radar situation. That's highly unlikely in relation to these FERC pipelines. Inclusivity is the idea of these processes, and you're unlikely to be able to hide the ball. Affected landowners is a term of art. That means at least every landowner whose property is going to be crossed. The details of that are probably a little beyond the scope of what we're talking about here, but it's every landowner whose property is going to be crossed, plus some. The permitting agencies are really at the center of the pre-filing process, right? Depending on what sort of environmental issues are involved with your pipeline, Fish and Wildlife Service, EPA, the Corps, even state environmental agencies, as we'll discuss later, will all be involved in various aspects of permitting. And the idea of pre-filing is to bring these agencies into the process and engage with these agencies through a public participation plan, so that the pipeline proposal that eventually comes out of this process is in line with the requirements of those agencies. So while all this agency interaction is going on, behind the scenes, or at least outside the public eye, the public is given this open house opportunity. And the open house is held by the pipeline company, so that the proponent of the project holds the open house. Typically, though, you're going to see FERC staff participating in that open house. And as a stakeholder, you get a chance to attend this open house, learn about the project, and start voicing your concerns. And again, if you're seeking to influence this process in a certain direction, in my view, it's not good enough just to attend this open house and listen. Now is the time early in the process to come with a strong, supported position for what you hope to accomplish out of this process, right? So identify objectives early on. Identify the objectives you hope to accomplish, whether that's defeating the pipeline as a whole, whether that's modifications of route, whether it's modifications of construction technique. Identify what those objectives are and begin pursuing those. Find support for those specific objectives and begin using that in relation to this open house. Don't be afraid to follow up contact with the project sponsor for raising questions and concerns to FERC. You've got to try to get the most out of this pre-filing process, and that has to be more than just sitting in on the open house. And getting the most out of pre-filing absolutely has to include involvement in NEPA. And NEPA enters the picture for the first time. Our National Environmental Policy Act enters the picture for the first time during this pre-filing process. Okay, so I said that the Natural Gas Act doesn't address environmental concerns, but in a way it doesn't really have to, because NEPA picks up those environmental concerns and runs with them. Just to give you I know NEPA is going to be discussed in later episodes, but just to touch on the history of NEPA a little bit. There was a time prior to 1970 where we had all these federal agencies out there making decisions under their various enabling statutes. They would choose between alternatives, and maybe one alternative action would have a very significant environmental consequence, but agencies would take the position that, unless their enabling statute mentioned the environment, environmental impacts were beyond the scope of their consideration. You can make that argument in relation to the Natural Gas Act. But NEPA was passed in 1970 with the idea of bringing environmental concerns into all federal decision making. Right, so you can't take a federal action now without accounting for the environment. That includes approval of natural gas pipelines. The first step of NEPA is what's called scoping. After FERC issues their notice of intent to commence this NEPA process, you have the opportunity as a stakeholder to participate in scoping, which is the process that the agency FERC uses to determine the range of issues that are going to be addressed in the NEPA process, right? So you may say, well, you need to consider groundwater in relation to this pipeline, or you need to consider endangered species or threatened species in relation to this pipeline. Those are scoping issues. Will the NEPA process for this pipeline take on the issues of groundwater or endangered species or whatever other issue you might want to raise. And this is another important opportunity for input in the pre-filing process, right? It's critical that you submit a comment letter on the scoping process, because you're really in a position of speak now or forever hold your peace, because in this pre-filing process through scoping, that's where the breadth of the eventual NEPA environmental assessment or environmental impact statement, the scope of those documents is set in this pre-filing process. You have an opportunity as a stakeholder, as a member of the public, to comment, to do the work, to identify the issues that need to be covered through the NEPA process, and to interject those through the scoping comment period. Sometimes FERC holds scoping meetings. That was not our experience in relation to the pipeline that Shelley and I worked on together. But if you have a scoping meeting, that's another important opportunity for public input. But again, pre-filing, you can see here from the pre-filing process, whether it's through the open house or through NEPA scoping, if you're a stakeholder, this pre-filing process may be your best path for getting your issue addressed without having to resort to an extreme step like litigation. Okay, Shelley. Once again, I know that NEPA is going to be discussed later, but since it is so intertwined with the Natural Gas Act process, I wanted to cover just a very brief primer on NEPA to be filled in later. When FERC issues a permit, that is a federal action. So you look at the triggering event for a major federal action. When FERC issues a permit, that is that federal action that brings it under the umbrella of NEPA. And NEPA says that the environmental impacts of a federal action must be considered before a final decision. The largest controversy for these pipelines in relation to NEPA is often whether an environmental impact statement will be necessary, or just, I say just in quotes, an environmental assessment, an EA, whether you have to prepare, you as the FERC or the pipeline proponent, whether you're going to have to prepare an environmental impact statement or an environmental assessment. I teach environmental law at Furman, and the way I describe the environmental impact statement to my students is as a dreaded behemoth. I think that's an accurate characterization, right? Those of us who've been around this type of work know that nobody ever wants to do an EIS because of the volume of work and time that it's involved. The way the law works is that if an action is going to have that significant effect on the environment, as you see from the triggering language there, then an EIS is necessary. If the effects are uncertain, if you're not sure whether the effects of the project are going to be quote unquote significant, then you prepare an environmental assessment, and an environmental assessment almost always leads to a finding of no significant impact. So the way it works is that if there's going to be a significant impact, again, term of art, EIS. If there's not going to be a significant impact, typically head toward the EA. And the long and short is, if you want to make a project more environmentally friendly, if you want to accomplish a major change in a proposed pipeline project, an EIS is more likely to get you there. So you have to use your public input to push for that environmental impact statement. On the other hand, I'll say that an EIS is it certainly is not a given for these pipeline projects. I look at a pipeline project like Shelley and I were facing, what did you say, something like 70 water crossings, cutting across 3 counties. That seems significant to me. There was no EIS prepared for that project. Now these vast sort of regional pipeline projects that cut across multiple states, you typically see an EIS there. But for an in-state pipeline extension, it certainly is not going to be a given that you're going to land in EIS territory. You see there that the NEPA is procedural and not substantive, and I know that a lot of you all probably know this, and I could talk again as an academic, a semi-academic, I could talk about this for our entire time about what that means. But the basic idea is that once the federal agency's complied with the procedure of NEPA, it has full discretion on the substantive decision, right? It's just a stop and think statute. NEPA doesn't necessarily protect against environmental harm. It protects against uninformed decision making. The reality, though, is that that substance and procedure line is very difficult to draw, if not impossible to draw for courts. The reality is that the NEPA process can give you leverage, can put public or political pressure on a project, or bring any other number of forces to bear that can accomplish a substantive outcome. But understand the nature of NEPA in terms of what it can and can't accomplish for you in relation to this process. But NEPA, if you're gonna find a way to get at one of these projects, NEPA very well may be your saving grace. And that saving grace, that opportunity comes through two main opportunities for input. I've got listed there in the final bullet. You have an opportunity for input in relation to scoping, where you can say, this NEPA process you really consider water quality impacts or sea level rise or whatever issue you may come up with. And then there's the opportunity after FERC scopes the project under NEPA. At that point, they'll decide to issue either an EA or an EIS, and then they'll issue a decision document, either the environmental assessment or the draft environmental impact statement. At that point, you'll have another opportunity, you as stakeholder have another opportunity to comment and point to deficiencies in the NEPA document and the EA or EIS, right? So you have those two main opportunities to influence the decision making, to push for an EIS and to push for incorporation of alternatives and environmental considerations that are appropriate under the circumstances. Okay. All right. So with that NEPA aside, just to bring us back to the context we're talking in here, NEPA scoping is going to occur during our pre-filing process. Okay. So NEPA scoping occurs during pre-filing. The choice between EA and EIS and then the creation of that document are going to occur after pre-filing during the actual certificate application process. So here's what we get out of this first phase of the administrative process. Is pre-filing outcome produces what you see listed here. The main idea, again, rather than a pipeline company applying for a certification and discovering all these landmines and problems, you discover those problems during the route creation process and pre-filing, and then when you apply for certification, it all goes that much smoother. As a stakeholder, if you have a problem that you want to identify, you've got to get it out there. You get a preferred route as the pre-filing process builds toward a preferred or proposed route. Keep in mind that the NEPA still requires consideration of a range of alternatives. So you're not going to put all the route alternatives to bed, but after pre-filing, you're going to have that preferred or proposed route. And again, you can start seeing entrenching into that position. Investments start, property negotiations start. So keep in mind, from the perspective of a pipeline builder, pipeline company, they have to negotiate dozens, if not hundreds, of property crossings with individual property owners. And the idea of negotiating with those property owners along your proposed route and then changing your route and validating all those negotiations and starting over, I mean, that's they're going to go to the mat on that, and that's going to be something that they're very unlikely to take on. So once you get that proposed route chosen and those negotiations start, you're almost working from behind the eight ball. That's why it's critical to have this early input. You get your scoped project out of NEPA, where FERC, the agency, says we'll address endangered sturgeon or we won't. We'll address impacts to climate change or we won't. They'll cover the scope of environmental issues that will then be evaluated in the EA or EIS. Just the way it's worth noting the way that works as the process proceeds. Pre-filing is really a great innovation as it relates to NEPA. When an applicant applies for the certificate, they have to come forward with an environmental report. That's part of the application process. The application requirement includes an environmental report. The NEPA scoping that takes place in pre-filing informs that environmental report, right? So the environmental report covers the issues that are scoped during pre-filing. If you imagine a situation where the pre-filing is not in place and the environmental report is just coming out of nowhere with no previous public input, pre-filing significantly increases your odds of getting a well-informed environmental report, which then leads to a well-informed EA and EIS. But at the end of pre-filing, you're taking inventory as a stakeholder. Hopefully you've interjected relevant environmental issues into the NEPA process, right? Hopefully you've identified what the critical environmental issues are, and you've gotten those into the process through scoping. Hopefully you've identified, you've done the work to identify desirable route modifications, right? Avoid this track, avoid this resource, and either made those modifications a part of the preferred route, or at least gotten them on the table through the pre-filing process. I'll tell you that relatively minor modifications to the route, like I was just describing, this track, not that one, are a lot more realistic objectives for you at the end of pre-filing than a drastic shift in the path of the pipeline. I have noted there no intervention. I'll talk a little bit more about what intervention means exactly, but keep in mind that you're not allowed to intervene. Nobody is allowed to intervene during the pre-filing process. Intervention comes when the actual certificate application comes under the Natural Gas Act, which takes us to the next slide. So here are your application contents, and there's nothing groundbreaking here. It's all the things you'd expect to see in the actual permit application. And of course, it's not technically a permit, but I think that's a good way to think about it. This will be, when you get this application for the certificate, this may be your first chance to take a hard look at what's come out of pre-filing, right? You look at the application and you can determine whether you've accomplished your desired changes through the pre-filing process. I'll say, and Shelley's already touched on this, translating the engineered drawings that are going to be in this application, taking those engineered drawings submitted by the company and translating that into on-the-ground impacts. That's a complex and time-consuming undertaking, right? You've got these maps and drawings, and that are going to come with the application, but figuring out what properties those cross and figuring out what resources those are impacting on the ground, incredibly difficult. Upstate Forever did incredible work on that in our pipeline project that we worked on together. It's important that you start this process right away. When you receive this information as part of the application, start putting it all together on the ground, because it's not going to be easy just to look at this application and pick out the problem spots. It's going to require research. It's very likely going to require identifying and contacting the individual property owners to assess and evaluate the resources that are at stake on these properties. You see there that the environmental report is part of the application content. You're going to want to begin reviewing that environmental report to inform your participation in the NEPA process. You're going to have an opportunity to review the EA and EIS. Those documents are going to be based on the environmental report. So take a look at the environmental report. Have they incorporated all issues that were raised in scoping? Begin setting the stage for your further NEPA participation. And then you'll want to look particularly at the other agencies that are going to be involved in permitting, right? One of the application contents includes info on permits required from other agencies. And you're going to want to start looking at what other agencies are going to be involved in permitting this project, thinking strategically. When you get this application and see that information, it's a time for strategic thought, strategic analysis in terms of what opportunities those agencies give you to affect the process. We're talking about how you can influence the process through FERC, but if Fish and Wildlife Service or the Corps or DHEC is involved, you'll see it through this application, and you can start strategizing as to what other avenues you may have to accomplish the objectives that you're seeking. The application includes even more notice. If you didn't know already from pre-filing, you'll find out through this notice. And just from a general perspective on that, I'll say that there's strength in numbers we found, strength in collaboration. There's lots of property owners out there that are affected by this. They know the resources, they know the properties better than anyone else. Tracking down these owners, as Shelley and Upstate Forever did, discovering the resources. The sooner you can start that collaboration, the sooner you can build not just you acting as an independent actor, but the strength in numbers, the better off you're going to be in terms of influencing this process. Okay. So I mentioned intervention. You can intervene in pre-filing, but when the certificate application, the permit application is filed, and that Federal Register notice is published by FERC, that triggers your timeline for intervention. It's actually quite a tight deadline for intervening. Typically, it's 21 days. That can vary depending on the circumstances. There is relatively liberal forgiveness in terms of filing for an out-of-time intervention. And out-of-time interventions or late interventions are are granted with some regularity. Of course, as a lawyer, I have to give my disclaimer: don't rely on getting a waiver for timeliness. And if you're a property owner and you find out late in the game and you're somebody who's directly impacted, chances are you'll be able to intervene late. If you're an environmental group or an agency or some other party, you need to work towards getting that intervention in as quickly as you can. As for intervention, I'll say generally that intervening on a project that's been filed with FERC, it's important and invaluable. It's important and valuable to file for intervening. I think if you're a stakeholder and want to accomplish anything in relation to this project, I think intervention is worthwhile. First of all, just from a general standpoint, it shows how strongly you are opposed to a project or a particular aspect of a project. It shows how closely you're following the process. Critically, it preserves your right to bring an administrative or a legal challenge if you decide to do so down the road. We'll mention that again in a minute. And it assures that you're going to be fully informed about each step of the process. You see there, interveners get electronic notice. If you're an intervener, you'll be sure to be on top of all the filings and all the action that goes on in relation to a certificate application. And the distinction in here is really between an intervener, which is someone who goes through this process of intervention that I think Shelley will tell you a little bit about how to accomplish that from a practical standpoint electronically. The distinctions between an intervener and someone who files a public comment. Right? FERC is required to consider, and I'll put that word in quotes, all public comments. So, you submit a public comment, that's going to be read and considered by someone at FERC, but that doesn't make you a party to the pipeline review proceedings. Just because you submit comments doesn't mean you're a party in interest to these proceedings. The intervention makes you a party to the action. It gives you the right to file briefs, to attend hearings, and again, critically important for the appeal rights. Only an intervener has the right to challenge a FERC certificate beyond its issuance by the agency, right? So when FERC decides to issue a certificate, if you're not an intervener, that's it for you. That's the end of the road. If you've intervened, then you have the right to pursue administrative and judicial appeal processes that we will talk about toward the end of my presentation. And even if you don't, I think it's important to note that even if you don't have any expectation of appealing certification decision, becoming an intervener is important just from a leverage standpoint, right? So, let's imagine you have a major objection to a particular aspect of the pipeline, like you've got a particular problem you want to address. You submit your comment letter, but you haven't intervened, okay? So from FERC's perspective, they see this problem you've identified, but they're thinking, well, if we don't address this problem, if we don't modify the pipeline to address this problem, what is this party going to do? They don't have the right to appeal. If we issue certification without making this change, there's nothing this person can do about it. There's no threat of appeal. Compare that to an intervener that FERC knows could take it to court over whatever problem or objection the intervener is raising. Whether you call it leverage, whether you call it a bluff, or whatever you want to call it, even if you don't intend to litigate, intervention is still valuable. Okay, Shelley. So here's your standard under the Natural Gas Act, right? This is the standard for issuance of the certification. And as I said at the very beginning, the Natural Gas Act and the standard are very much driven by the market considerations. Public interest is the defined standard. That's the definition. But I would say that that's a bit of a misnomer, because it's not the public interest in all things. It's the public interest in affordable and abundant natural gas, right? Does this pipeline proposal further the public interest in a vibrant natural gas market, not the public interest in all things. Under the Natural Gas Act, that public interest in that market is assessed by looking at a few different factors that I've listed here. Pipeline competition. FERC is left to determine, is this a matter of another pipeline improving competition, which is a good thing, or is it a matter of oversaturation, which is a bad thing? The pipeline proponent can't be in a situation, they have to be financially viable in terms of building the projects without just passing the cost on to their existing customers. And then one that Shelley and I looked at in pretty significant detail during our project was customer commitments. and the idea that there are people on the line, entities on the line that actually want the natural gas that's going to come from these pipelines. Shelley and I discovered, though, that FERC's not going to look deep on this issue. If the pipeline proponent comes forward and says we have these commitments, even if they're unrealistic, even if there's reasons to believe that that those commitments will not be upheld, FERC's not going to look below the surface on that. They're not going to question they're not going to question how wise or unwise a business decision is by the pipeline company. They're not going to say, well, you say you've got these commitments, it's just like a risky business decision. They're not going to look that deep. They're just going to look to make sure that it's there in black and white, that the commitments are listed. And then they look at some supply chain things in relation to the pipeline infrastructure. Keep in mind, we're looking here and we're talking about all these marketing things. While the Natural Gas Act is focused on these things, while all this is going on, there's simultaneously going to be an environmental review going on through NEPA. There's going to be environmental review going on through other federal environmental laws that we'll mention in a minute. So this is not the full extent of analysis for the pipeline. It's only that occurs under the NGA. But aside from market considerations, the two big things that are going to be looked at through this FERC process are the environment and then eminent domain. And we'll take a look now at both of those, how both of those considerations are accounted for in the process. So environmental limitations on the pipeline, we've already talked about NEPA. I won't beat that statute anymore. You're going to submit your comment letter during this certification process. You're going to submit your comment letter on the EA or the draft EIS. And try to bend that process in the direction you want it to go. I will mention one recurring note that I encountered with Shelley's pipeline, and that comes up very regularly if you follow these things in the news or in the courts, the issue of considering greenhouse gases. So you might consider greenhouse gases an indirect environmental impact of these pipelines, because if you look at it very narrowly, it's just a pipeline construction, but obviously these pipelines aren't being put in the ground just to sit there inactive. They're going to carry gas, and then that gas is going to be burnt, releasing greenhouse gases. And do those greenhouse impacts have to be considered within NEPA? That's been a recurrent issue. And just to sort of summarize the progression, I think a full consideration is probably beyond our scope here. But we saw an expansion where FERC was more likely to consider those impacts. We saw a contraction, and now I would say we're in a period of confusion, where some courts are leaning toward more consideration, and some areas that consideration is not being shown. I'll just say for our purposes here that if your intent is to make this project more environmentally friendly, absolutely you need to argue for consideration of greenhouse gases as part of the NEPA process, but keep in mind that you're going to be on uncertain legal terrain in doing so. Apart from NEPA, the big statute, which will be filled in your next webisode, is the Clean Water Act, Section 404 and Section 401. And I'm just going to give an overview of that statute because it is so critically important. If you have a pipeline of any length in this part of the world, right, you're going to have crossings of water bodies. And whether that water body be a lake, a river, a creek, a wetland, a stream, and what 404 and 401 regulate is the placement of fill material in a regulated water body, which is going to be all your creeks and rivers and lakes of any size. Again, we could talk for the whole time about that, wetlands. But placement of fill into those regulated water bodies triggers 404, which is a federal permit, and triggers 401, which is a state certification of the federal permit. And what Shelley and I saw was that when these pipelines are built, they're typically drilled beneath the major water bodies. So you're not going to see them typically crossing major rivers, but smaller creeks and smaller wetlands and water bodies are going to be crossed, triggering this requirement for the Clean Water Act permit. The Corps, the Corps of Engineers, the Army Corps of Engineers administers Section 404. So the federal component of this permitting program is administered by the Corps, and the Corps has been what I would describe as extremely deferential in this area, which means the Corps process has been of very little use in terms of influencing these projects. to the point where the Corps is very regularly using Nationwide Permit 12. And for those of you who aren't familiar, what a Nationwide Permit means is that it's a class of projects that the Corps has set aside and said that as a category, these type of projects are permitted rather than individual review. We're going to permit them as a class, and it really cuts down on the review of the specifics of a project. Also, very detrimentally, typically when you have a nationwide permit, there's no mitigation required. And that was something that Shelley and I ran into. Mitigation often is an enormous deterrent for people who propose to fill wetlands or water bodies because it's expensive and difficult. But for our pipeline, there was a nationwide permit used, which meant there was no mitigation required, and that was not an obstacle at all, which led to what I would say was a proliferation of water and wetland crossings. So that's 404. 401 is the state certification of that federal 404 permit. So we talked at the very beginning about preemption, right? State preemption, loss of state control over these gas pipelines. Here is your chance. Here's your chance to lean on the state, to utilize state law and state processes to try to make these pipelines more environmentally friendly or more or less disruptive to your property or whatever your objective is. This is likely your only and definitely your best chance to utilize state control in this process. And the way that 401 works is that the federal permit has to be certified under state standards. There's been some discussion and some controversy relatively recently about whether a state can basically deny 401 certification and essentially stop a pipeline project. And the way that that's been going lately is to say that absolutely they can, right? So if a state denies 401 certification, that is that the pipeline does not have all the approvals it needs to proceed, and that would stop construction. Otherwise, as we've talked about, the state has very little or no control to stop these pipelines. And it also 401 also gives the state a level of continuing oversight under 401. So an extremely useful tool. And then if 404 and 401 are issued, you can always bring a legal challenge to those certifications and permits. Really important to note here, if you challenge a 401, usually if you challenge the 401, you find your way to state court. The Natural Gas Act says all legal appeals related to a natural gas pipeline go to the Federal Court of Appeals. So in a very unusual turn here from a legal standpoint, if you were to challenge the state certification under 401, you would go to, if you're here in South Carolina, the Fourth Circuit Court of Appeals. That comes with a whole host of challenges that you typically don't encounter, in a legal challenge on this level. Beyond the Clean Water Act, you go to the Endangered Species Act. There's two sections of the Endangered Species Act that are relevant here, Section 9 and 7. 9 applies to everybody, and 9 is what's typically called the taking provision. If you're performing an activity that's going to harm individual members of an endangered species, that's unlawful under the Endangered Species Act. So if it was a situation where this pipeline was being constructed through a forest where an endangered bird was nesting and it was going to disrupt that nesting, or if it was going to eliminate wetlands utilized by an endangered salamander, that would be potentially a Section 9 taking. Section 7 only applies to federal agencies like FERC, and it has a NEPA-like consultation requirement, which requires FERC to consult with Fish and Wildlife Service if it's taking an action that potentially jeopardizes the continued existence of an endangered species. So Section 7 is a little bit of a broader inquiry. It comes with consultation and more opportunities for public involvement. If you're lucky enough, I put that in quotes because you'd be lucky in terms of your ability to advocate and potentially influence a project. If you're lucky enough to have potential endangered species impacts related to this wetland, that gives you a whole new set of tools that you can wield in this process. Coastal Zone Management Act is another statute that has shared responsibility between federal and state. So the OCRM, division of DHEC here in South Carolina, administers the state side of the Coastal Zone Management Act. And just like 404, 401, there's a component of state certification. So if a pipeline is being constructed in the coastal zone. This may be another opportunity where you could get some state input, some state oversight, and potentially have some state influence over the direction of this pipeline where you're otherwise foreclosed. And then the other one I'll mention is that there's a typo here. It's SHPA. It should be NHPA, National Historic Preservation Act. Once again, this is another consultation statute, just like Section 7 of the Endangered Species Act. It requires the Commission, FERC, to take into effect the impacts of its project on historical property and to consult with the relevant federal agency in terms of minimizing that impact. Once again, those are going to come up just depending on the circumstances of the pipeline route. And often what you'll see, I would say, is the pipeline, through the pre-filing process, the pipeline will be designed to, as much as possible, choose a route around Endangered Species Act or Historic Preservation Act issues, just because that significantly minimizes the amount of disruption and hassle that the pipeline company is going to have to go through.
I'll just I'll throw in just a little bit here about consultation of tribes. And what we learned on our pipeline project is that the only tribes who are consulted are the nationally recognized tribes. So we had a state recognized band of Cherokee in our area, but they were never notified of this situation. Everything went to the national organization. So that is just something to be aware of. Tribal consultations are part of the process, but they're only going to consult with the nationally recognized tribes. So it's important to stay on top of everything.
Thanks, Shelley. And now we'll get to I'd say the most depressing part of the presentation, the most surprising, if you're among some parties, maybe the most enraging part of the presentation, which is the property limitations on pipelines, and which brings in the concept of eminent domain. And what you'll see with this process, the FERC approval process overall, is starting in pre-filing, going through the certification process, even through post-certificate appeal. The entire time, the pipeline company is going to be negotiating with property owners whose properties are going to be crossed by the pipeline. They're going to be trying to negotiate access rights, right? They're going to try to negotiate a path across the property for a set price with every property owner along the route. If you think about it, in terms of hours spent, I mean, that's probably the biggest part of this entire undertaking, is the time and effort committed toward all those contract negotiations. As a lawyer, it makes me cringe to think about having to negotiate that many contracts. But it makes it a little easier from the pipeline company standpoint, in that the final outcome is already determined, right? The game is already won before you even play, and that's because of eminent domain. Now, I'm sure most everybody's familiar with the concept of eminent domain. Typically, it's utilized by government entities, like the Department of Transportation uses eminent domain for road projects or road expansions. Typically, public entities, government entities, are using eminent domain for public projects, public infrastructure projects. Here, the Natural Gas Act gives private pipeline companies eminent domain power once they have their certificate in hand. And we observe, Shelley and I observe, this is really a shocking fact from the standpoint of the average citizen and even the average politician, to find out that a company that's pursuing maximization of private profit, right? These pipeline companies are trying to make as much profit as possible, and in the process of doing that, they're allowed to exercise eminent domain to take your property without your consent. Something that is startling to a lot of folks, but it's true. While South Carolina's passed laws to try to protect private property rights for other pipelines, there's nothing they can do about this natural gas pipeline. Now, FERC, in the process of considering its certificate, it's supposed to consider how much eminent domain will be necessary, and it's supposed to steer the process toward routes that require less exercise of eminent domain. I personally haven't observed anything like that. I know personally, Shelley and the pipeline that Shelley and I were involved in, there was a route which essentially would have required no use of eminent domain. It would have been within an existing right-of-way, mostly within public property, and that alternative was rejected in favor of an alternative that required dozens of exercises of eminent domain. So FERC's not going to do much to protect you on this front either, which is really why I have my bleak outlook here. What can you do? Well, not too much, frankly. State and local law are preempted. And where are you as a property owner? Let's suppose you're a property owner who doesn't want to sell. You don't want the pipeline to cross your property. You don't want to sell, no matter how much money they're offering. You don't want to sell. That's not an uncommon position. Can you go in, if you decide to litigate it, right? Can you go in and convince the court that FERC shouldn't be allowed to cross your property? No, you can't do that. That's not within the scope of eminent domain litigation. Can you somehow defeat the use of eminent domain? No, can't do that either. That's beyond the scope of eminent domain litigation. If you won't negotiate with FERC and they take you to court in a condemnation action, the only thing the court is going to consider is money, is the price. All you can do is negotiate price. Whether you do that through informal negotiations or whether you take it all the way to court and try to litigate to get the highest value you can, all you're going to be able to argue about is money, because there's no way to defeat eminent domain once FERC has their certificate. And from a practical standpoint, as a legal advisor, very often the amount of money you would spend on a lawyer going in to litigate this issue is going to eat up any profit that you get by getting a higher value out of the court process. It really puts property owners in a very tight spot. All you really have to lean on is old-fashioned negotiation strategies. Try to maximize your leverage and use that leverage to get as high a price as possible, or to get some other route concession, some other minor change in route that you have in mind. And you can get that leverage by participating in the process, by being an intervener, by commenting at every opportunity. FERC doesn't want to litigate these things. They want to minimize. The pipeline company doesn't want to litigate. The pipeline company wants to minimize their hassle and get these things approved, these pipelines approved as quickly as possible. If you as a property owner look like a big hassle to the pipeline company, then the pipeline company is going to start seeing minor route concessions as a more reasonable and prudent alternative. Unfortunately, I say unfortunately as someone who works in the public interest, often it's the big money, big power property owners that are able to muster the amount of leverage that's needed to get these concessions that we're talking about. So my advice to a property owner facing eminent domain is to be realistic, come up with a very specific objective, pursue modest but meaningful concessions in the route. If you get up and just are mad as hell about them crossing your property, it's not going to get you anywhere. Find a modest objective and you maximize your leverage to pursue that objective. All right, Shelley. And that gets me to my last slide, which is what happens when certification is issued. And, very likely, I think the title of the slide is apt, because very likely you're going to be in a situation where the certification is issued. Some groups and some entities have had success defeating certifications in court once they're issued. Very few have actually been able to defeat the certification at FERC. But when the certification decision is issued, you of course get your decision document that spells everything out, lays out the final route, all the information you're going to need. If you've intervened, and only if you've intervened, then you have the ability to request reconsideration of that decision. Reconsideration is an administrative process. It's entirely within FERC. As if you're a non-lawyer or a non-practitioner, it probably sounds pretty strange, but you ask the FERC commissioners to change their mind on the decision that they just spent months and months making. obviously very unlikely that they'll reconsider, at least reconsider in terms of denying a pipeline that's been approved. But reconsideration is a required step, mandatory that you exhaust your administrative remedies, and one of those administrative remedies is reconsideration. So if you want to take this to court, if you want to take it all the way to judicial review, you have to ask for reconsideration. You have to do it timely. I'll say from personal experience, you have to do it by 5 p.m. on the deadline. Everybody remember that one. That's an easy one to get you, and especially as cumbersome as the electronic filing system is. And then finally, one oddity here, and one more thing that stacks the deck in favor of these pipelines and makes this, one of the most difficult projects to get at from an environmental law standpoint or an environmental stakeholder standpoint. Any judicial appeal, rather than being to federal district court, which is in your community and has procedures that are cumbersome, but are at least within the grasp of many local attorneys, you have to bring any judicial challenge has to be brought to the Court of Appeals for the circuit where you reside. Again, that's Richmond here in South Carolina. That's Richmond Fourth Circuit Court of Appeals. Very daunting task to think of pursuing a Fourth Circuit Court of Appeals challenge to one of these pipelines. Again, one more place where the Natural Gas Act sets the cards in favor of approving these pipelines and diminishing your efforts to oppose. Shelley, take over from there.
And on that bright note,
yeah, sorry for being too cynical, but gotta be realistic here.
All righty. Now, how do we monitor dockets? How do we find out what's going on at FERC, and particularly those pre-filing, those very important pre-filing dockets? So here I'm going to just show you quickly through a couple of slides where to go on the FERC website, and that's just www.ferc.gov. And then you're going to go, if you see across the top where it says Documents and Filings, drop that down and you will see e-library. So again, not intuitive really at all, but Documents and Filings first, over to e-library. Then this is the page you get. An e-library, you want to do, just to monitor things, you want to do a general search. So you just click on General Search, and you get this beautiful page. From here, what I typically do is for date range, I'll hit, if I'm being really good and monitoring every week or so, I might, say the previous month or something, but typically I just pull up the whole last year, or I'll say all. And this is for monitoring the pre-filings, those critical pre-file dockets. Just, if you're not a property owner who's going to be impacted, this is just about the only way you're going to know that something's coming, unless you happen to catch a legal ad in your local newspaper, which we did, but it wasn't for the pre-filing. The pre-filing is not, I don't think, is noticed in the newspaper, but the certificate filing was. So now I watch for pre-filings. So you go, and you can do both. First, for pre-filing, date range, all, or you can limit it. Category, you want both of those. You want to choose natural gas. Then, to just pull up everything that's been filed pre-filing, you use the letters PF. And so for 2018, PF 18 and then asterisk. And that will get you something like this, which is everything like that. I prepared this, looks like on October 2nd. So that'll get you everything that has, all the different pre-filings, PF 18.7, PF 18.4. PF 18.4 is the Southgate, is the Mountain Valley Pipeline Southgate project. PF 18.6. And you kind of go through and you figure out what the different projects are and where they are, and then you know your docket number after that. So before I proceed, I'm going to go back to this one. So that's just sort of just to monitor the pre-filings. To take a look at the certificate filings, it would be CP star, CP 18 star, and then you'd see the new certificates filed in 2018. Now, if you want to look up, if you have your docket number, this can be confusing. If you have your docket number and you want to look up everything filed in your docket, and then you can subscribe to that docket and have them send you new filings. You would say, for example, CP 14-103. Now, usually there are 3 more numbers at the end of a docket number. Like that full docket number is CP 14-103-000. That's for Elba Island. But for the purpose of searching on this, and they don't really tell you, you just use the 2 letters in either PF or CP, and then the year that you're interested in, or the year it was filed, and then the first 3 numbers, 103 or whatever those might be. So, and then I don't worry about subdockets or document types. I just click submit, and then I get something that looks like this. On this page, this is more general, but if I were to click in for a particular docket, or although it applies to this as well, some documents are public, some documents are private. If you see a document that has CEII, that is critical energy infrastructure information, and it's considered confidential. So you're not going to be able to look at that. The only things you're going to be able to look at are the documents that are listed as public. Now I'll draw your attention to my lovely blue box. If you look at that, that is 2 dockets together. What we have there is the original Mountain Valley Pipeline certificate docket, CP 16-10. And then when they filed the Southgate extension, that project was a pre-filed because it was a separate project, but yet it's linked to the first project. So you have those 2 dockets together. So you've got a CP 16-10, which is the Mountain Valley Pipeline, and you could go in and just search through thousands of documents and entries there. Or you can just go in and look at the PF 18-4, which is specific to the Southgate project, which is the project that brings it into the Mountain Valley Pipeline into North Carolina. So that's just sort of an example and an overview of what it looks like. It's not very friendly, and it can also
Kelly,
be.
I was just going to jump in to say that, I mean, I can't overemphasize how sort of inflexible and dumb the FERC search engine is. And I spent more time than I would like to admit just trying to get the relevant documents to pull up, because it is so cumbersome and allows for no flexibility at all in terms of entering exactly the right characters to get what you're looking for to pull up.
Yeah. So that's what you're going to be, that's what it looks like. So, hopefully being a little familiar with it will be helpful. And it said anything that says public, you should be able to pull it up. I do frequently have access problems with it. That thing goes down a lot. I think, Michael, you had that as well, right?
We had it the day that our reconsideration was due. Yeah, it seems to go out at problematic times too.
Yeah, so keep that in mind if you're uploading or filing anything. But that's your basic intro to how to navigate that website. You can go down all sorts of rabbit holes on it, but that's your sort of preliminary introduction to all that. And I'm in the interest of time. I guess, let's see, we have about 15 minutes left. First, I'll say if you're interested in episodes 2, 3, and 4, we put a banner up on the front of our webpage, www.upstateforever.org. You can just go straight there to get to the link where you register for those 2, 3, and 4. So we've made it pretty easy there. If there are any questions at all, type them in the question box. And if there aren't, then we all get back 15 minutes of our lives. So are there, I got, okay, no questions at the moment. I'm going to include, well, if that's that, I'm going to, this is our contact information. For me, I'm Shelley Robbins, srobbins at upstateforever.org. Michael is michael at skelp.org. So feel free to email us. And again, this is, this is the tip of the iceberg on all of this. We will go into a lot more detail on the water issues and the 401 on Wednesday. Then on Monday, I'm going to talk about construction and decatherms and welds and all kinds of fascinating things. Just because it does help to understand. It helps to understand that, that what is happening when that thing is coming through your community. And then the last one, we will talk about the impact on conservation easements, timber properties, how we got that magic list of property owners and was able to connect them and to connect them with information. And then also various monitoring programs that other organizations have used. There have been some phenomenal ones in Virginia, for example. So with no questions, thank you all for your time. And thank you, Michael. And I hope to see everyone again on Wednesday. Y'all have a good Monday.